हेलो 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 दोस्तों, और फिर एक नया सैटरडे और एक और वेबिनार नंबर 10 डबल डिजिट्स में हम लोग पहुंच गए हैं। और लेबर लॉ एडवाइजर एक्सक्लूसिव मेंबर वेबिनार में आप सभी का स्वागत है। और धीरे धीरे हम लोग आगे बढ़ रहे हैं। थोड़े से सम एंडी यहाँ पे आ रहा है, देयर सम ट्रबल। अगर आप मुझे सुन पा रहे हैं तो कैन यू कमेंट? हाँ, आई गेस सुन पा रहे हैं आप मुझे। अगर आपको आवाज मेरी प्रॉपर आ रही है और वीडियो प्रॉपर आ रहा है तो एक बार कमेंट करके बता दीजिए, क्योंकि यहाँ पे कुछ लिखा आ रहा है कि कुछ तो एरर है। हाँ, मेरे ख्याल में लोगों ने ज्वाइन कर लिया है, दैट्स गुड। चलो, इसको मतलब एरर कुछ नहीं है। ओके, तो आज के इस वेबिनार में हम लोग बात करने वाले हैं इंडस्ट्रियल रिलेशन आफ्टर लॉकडाउन की। इंडस्ट्रियल रिलेशन को कुछ आप अगर बेसिक समझे तो इस तरह से समझ सकते हैं, इट इज अ रिलेशन बिटवीन एन एम्प्लॉय एंड एम्प्लॉयर, और ये ओवरऑल गवर्न किया जाता है जो उनके बीच में कॉन्ट्रैक्ट हुआ था उस पर। लेकिन ये कॉन्ट्रैक्ट में अगर आप लीगल प्रोविजंस का ध्यान में रखते हुए नहीं बनाएंगे तो उसे एक शैम कॉन्ट्रैक्ट मान लिया जाता है। और कई सारी ऐसी चीजें आजकल के एम्प्लॉयर करने लग रहे हैं जो शायद लीगल ही नहीं है। तो इन सारे विषयों पर बात करेंगे और स्पेसिफिकली बात करेंगे कि आफ्टर लॉकडाउन जो बहुत सारे टर्मिनेशन हो रहे हैं, इंडस्ट्रीज क्लोज हो रही है, इंडस्ट्रीज फाइनेंशियल स्ट्रेस में है, लेबर्स को, एम्प्लॉयज को, इवन मैनेजर्स को फायर किया जा रहा है, इन सभी से रिलेटेड हमारा लॉ, हमारा कानून क्या कहता है। और आज के जो हमारे स्पीकर हैं, मैं उनके बारे में अगर आपको बताऊं तो वो लेबर लॉ और इंडस्ट्रियल रिलेशन के वन ऑफ द लीडिंग अथॉरिटी है इंडिया के। आप पिछले 28 सालों से, 28 ईयर्स से इस फील्ड में लिटिगेशन, कंसल्टेशन और ट्रेनिंग देते हुए आ रहे हैं। आपकी फर्म मालेगांवकर एंड एसोसिएट्स इस फील्ड में पिछले 28 सालों से काम कर रही है। आपके पास न सिर्फ लेबर लॉज की डिग्री है बल्कि आप एमबीए और आपने पीएचडी, डॉक्टरेट की उपाधि ली है लेबर लॉज के अंदर। आपने न सिर्फ इंडिया में बल्कि अक्रॉस द ग्लोब, यूरोप में, अफ्रीका में ट्रेनिंग्स ली है, वेरियस सेमिनार्स लिए हैं लेबर लॉज के ऊपर। आप एक ऑथर हैं, स्पीकर हैं और वन ऑफ द लीडिंग अथॉरिटी है इंडिया में लेबर लॉज के बारे में। और आपकी जिन ब्रांड्स को आप कंसल्ट करते हैं उसकी लिस्ट आप जानेंगे तो हैरान रह जाएंगे। मर्सिडीज, फिलिप्स, 20 से ज्यादा बैंक्स, एनजीओस, बहुत सारी होटल चेन्स जैसे रेडिसन ब्लू, नोवोटेल, इन सभी को भी आप कंसल्ट करते हैं। तो मैं आज बहुत ही गर्व के साथ मंच पर आवाज दे रहा हूं लेबर लॉ के बहुत बड़े धुरंधर डॉक्टर श्रीकांत मालेगांवकर। अनिरुद्ध, आई रिक्वेस्ट यू टू प्लीज ऐड सर ऑन द स्क्रीन। सर, वेलकम टू द वेबिनार।
वेलकम
सर, क्या आज का किस तरह से हम लोग, आप क्या हमको ओवरऑल इस वेबिनार में किस चीजों पर हम लोग बात करने वाले हैं आज?
अभी फर्स्ट एंड फॉरमोस्ट मेरा मीडियम ऑफ इंस्ट्रक्शन इंग्लिश रहेगा।
दैट्स फाइन सर, नो प्रॉब्लम।
दैट इज फाइन। तो अभी हुआ क्या है कि आफ्टर द लॉकडाउन देयर आर टू मेनी इश्यूज व्हिच हैव क्रॉप्ड अप। उसमें सबसे दो, एज फार एज एचआर, मैनेजमेंट एंड द वर्कफोर्स आर कंसर्न, तो दो इश्यूज काफी मेजर है। काफी इंडस्ट्रीज दे आर क्लोजिंग डाउन, then some have already closed down, some are into financial problems, and then some call the workers and say that from tomorrow you need not come. Managers ko bulate hai bas. So what is the law behind it? Can they do it this way? Can they outrightly reject them? And this is the issue for wherein we are going to spend an hour, and of course thereafter would be question and answers.
Right,
So
sir.
I will be deliberating upon that. तो एंड बाद में क्वेश्चंस पीपल कैन आस्क मी इन हिंदी आल्सो, दे कैन आस्क मी इन इंग्लिश आल्सो।
Perfect, sir.
So
Perfect, sir.
yeah, जी
So the
जी,
stage is all yours, sir. Now you can start the presentation. I'll just go backstage.
sure, okay,
Thank you.
okay. Okay.
You can start your present. Are you on presentation screen, sir?
No, that's what
You
I'm.
can. You okay? No.
No, the presentation screen is not here.
Sir,
No,
please
no,
press escape. Please press escape.
Yeah.
Now, from your bottom, there will be your presentation. Then please click on that.
you go to the PowerPoint, sir. We will be able to see that.
Okay.
Yes, yes, it's visible, sir. Yes, you can do it full screen.
Okay. Can you
Thank
see
you.
me?
Perfect, sir. Perfect.
Yeah, yeah. And can you see the slides?
Yes, sir.
Okay. So I will start. Friends, now you see the topic which I chosen for our discussion, which would be somewhere about 50 minutes, and then I'll be taking up your question and answers. They are legal trends in reduction of pay and termination of employment, because these are the hot topics and cropping up issues amidst COVID-19 after the lockdown. Now you see, the COVID-19 is still in the air. As far as I'm speaking from Pune city, which is in Maharashtra, and here, I mean, there are some 2 to 3,000 cases per day even today. So, in this webinar, I'm going to talk basically in 4 points. That is, first is before the lockdown, what is the position? During the lockdown, what is the position? After the lockdown, what is the position? And this all would be amidst COVID-19, which is an ongoing process. Rather, Government of India as well as say Maharashtra government here also, they have already advised all citizens to now live well along with the COVID, rather than, I mean, treating COVID something which is, say, we leave it to the scientists whether they are going to find a vaccine or not. Okay, let us come to our topic. WHO, that is the World Health Organization, friends, confirmed that a novel coronavirus was the cause of a respiratory illness in a cluster of people in Wuhan city, Hubei province, China. As we all understand, this virus has traveled from China to an extent that Donald Trump went to the extent of calling this virus as a Chinese virus. And then there were no significant rise in cases in February. And then, as we understand, after February came March. On 22nd of March, we had the banging of the thalis at the request of Honorable Prime Minister Narendra Modi. And on 24th of March, really the lockdown began. I go further. Now, before the corona and before the lockdown, was it that India was bas ek sone ki chidiya and everything was rosy rosy all the way? And the answer is a simple no. Even before COVID-19 pandemic raised its ugly head and made our immediate future uncertain. Now you see, the Indian economy was already slowing down. If you see India GDP growth, it had already slowed down. Economic growth was on a downhill. And what has happened because of the pandemic has made it worse. Private investment is already plummeted, and this was the position before the lockdown. Now, during the lockdown, what happened is that the government had absolutely no option but to declare a lockdown. Otherwise, they sensed that so many people would die because of a respiratory illness. And then some said that this is a violation. The lockdown itself is a violation of life and personal liberty. And you understand, there are so many groups in India who challenged the total thing. And then the government invoked the, say, the provisions of the Disaster Management Act 2005 and the Epidemic Act of 1897. Now, friends, I will make things simple. Disaster Management Act, as the name itself indicates, is to control some sort of a disaster. And under the Disaster Management Act, there is a central committee, then there is a state committee which percolates down to the district magistrate, that is the collector. Central committee, which is headed by the Home Minister, they took out advisories. Advisory is like a circular or a notification. And that advisory was that nobody's pay is to be reduced and nobody is to be terminated from his services. And this was an all over India issue. Then what happened is the government issued many advisories. And then the lower thing you see, that is the Epidemic Act of 1897. 1897 is in the last century when there were things like plague. And this is an act which has been enacted during the British Raj. Now, under the Disaster Management Act, the Central Committee can enact such sort of advisories, pass it down to the state advisories, and the state advisories, I mean, the state government will will publish an advisory under the signature of the Chief Secretary. In state of Maharashtra, Ajay Mehta was the Chief Secretary, and then an advisory is issued that no, this is when we are talking, friends, during the Corona, that nobody's wages will be reduced and nobody is going to be terminated. Now you see this led to many hardships. It's in the fitness of things that I explain you as to what is the scenario. And there were hardships by employers. Employers have taken loans, crores of rupees. They have to pay EMI, work orders, but there were no work orders because of then airports were closed. Foreign people cannot come. Italy and then Spain and Germany and England and everywhere there were so many cases, and those states were also in a shambles. Employees also started facing so many difficulties. How will they run the household? How will they earn their daily bread? What will they eat in the evening? Were some basic questions which were faced by the Indian employees. Now you see, we stay in a country like India and we are brought up in households wherein we are taught since childhood that we have to help each other. On humanitarian grounds, the issue is very simple, that you have to pay somebody who is in distress, that he is say suffering, so I have to help him, is what you and me have been taught. So on humanitarian grounds there is no question that you have to help a person who is in distress. Now what happened is, once the advisory came, there were so many issues. What happens to the rights contained in the various labor legislations? Industrial Disputes Act grants so many rights to the workers. What happens to those? Whether those labor legislations stand repealed because of the incoming of the Disaster Management Act 2005. Moment you have the Disaster Management Act, what do you think? Are those labor legislations repealed? Are so many questions which came up. Now you see what exactly the COVID has done is, the pandemic has been a huge blow to India. Industries and businesses, they are the arteries and lifelines of the economy, and they face a great depression. Many Indian sectors are affected by COVID-19, are locked down, are indeed in a need of urgent relief. Even today, there are so many industries, they have went downhill. Why that? See, about Indian economy, I learned that to treat a COVID patient, you require a lakh of rupees. From where will the government bring it? A bulk of the job losses have been reported from critically affected sectors. I stay in a city called Pune, wherein there is an industrial cluster. People, I mean, so many of the employees are jobless. The overall impact of COVID-19 is now being felt in most sectors in the country. Economy is sick and the people are being deprived of their livelihood in the absence of supply of essentials. Now you see industries are at stake, electrical machinery, mechanical appliances, organic chemicals, plastic, there is no work, there is a job loss, there are layoffs, there is unemployment, pay cuts, lockdown, healthcare issues, job crisis, so on and so forth. You can see it on the slide. I go further. Now you see in the meantime, there were so many judgments which were declared by the Supreme Court. People challenged all these things. First is Alak Srivastava's case, where an Honorable Supreme Court said, once the Chief Secretary signs a document, you have to follow it. And what is the document signed? That is the advisory that nobody's services will be terminated and nobody's pay packet will be reduced. Supreme Court, this is a judgment by Honorable Chief Justice Sharad Bobde, wherein he said that Section 188 of the Indian Penal Code has to be given attention. And what does that say? That to disobey the order of a public servant is punishable in India. So everybody has to obey that. Moreover, in this judgment, Supreme Court went to the extent of saying that not only citizens, government servants, but even common citizens are to obey the judgment and help each other, and nobody is to be terminated, and nobody's pay packet is to be reduced. Then came 2-3 cases: Ludhiana Hand Tools Association, Ficus Pax versus State of Karnataka, Nagarika Exports, and at that point of time, all of them were only on one issue, that how can you allow reduction? How can I pay the salary? So allow us reduction of salary, which was rejected by the Supreme Court at that point of time. Then we had other cases, say Workmen versus Binni, wherein they say this is old law. Trite law means old law, that the labor legislations would ultimately stand in favor of the weak. So nothing for the management. Sham Sundar versus Ram, Supreme Court said a beneficial legislation cannot be given a retrospective operation. And in the state of Maharashtra, the Aurangabad High Court declared a judgment in Rashtriya Shramik Aghadi versus state of Maharashtra, wherein the issue of no work, no pay was also rejected. There were some employees who could not go to for work because of the lockdown, and the management said that as you have not come for work, we will apply the principle of work and no pay, which was rejected by the Aurangabad High Court. Now the Supreme Court, there were some ambiguities. First and foremost, in the judgments which were, economy is in a complete disarray due to depression. The tone and tenor of the MHA, that is, the MHA is the circular, that is the advisory which is given by the Ministry of Home Affairs. MHA is Ministry of Home Affairs. They said that it is coercive and intimidating. Business and production activities have come to a grinding halt. There are deterioration of finances, no work, no production, dried up revenues. Now you see, industry, shops and commercial establishments are to make payment of wages. And there is no order on the one hand. So on the one hand, you have stopped the tap and you are asking us to empty the bucket. How long will the bucket survive? And how long will the industrialist survive? There is no termination of casual and contractual labor. On the one hand, you also ask people not to terminate employees. One third of the employers, I am talking of an all India picture, did not even pay PF from April, which is mandatory. As you understand, PF, that is the provident fund. Employers were advised to get into negotiations and yield salutary results. Now, this is the total scenario. Now, the expected duration of the economic stress on the industry and the effective of government measures for the industry, you can see it in the slide. Now, there were restrictions on movement of people. You know, the issue of migrant labor. From Bombay, people started walking up to Bihar, then bringing the economic activity almost to a standstill. Most of the respondents don't expect the industry to recover soon. They are not confident of the effective measures to support their industry. Now, this is the scenario, and my topic today is post lockdown. So, we are going where? COVID-19's impact to the industry, friends. The key challenges faced are lack of raw material, productivity loss, insufficient staffing, accomplishing of critical work, and all of these were the problems. Okay, now it's a very difficult place. There is slow growth, blighted job market, crisis, weak demands, and the viral impact. What is the impact of the virus? Daily grind, layoff seasons. Now, friends, let me correct all of you. The layoff, which term which is understood in United States of America, is not the word layoff in India. In India, layoff is something different. That is, you cannot give work. The employer cannot be giving work due to shortage of coal, raw material, electricity, accumulation of stocks, etc. That is layoff. In America, layoffs means termination from the employment. And that is why most small and medium scale industries, big industries, everything have come to a standstill. Now you see, I'll just give you some examples. Maruti, Hero Motors, Bajaj, then in Mumbai, Monday, so many operations, Tata Motors, Hyundai, Honda, then Samsung, Godrej, Haier, some of them are my clients here. And then there was everybody was bearing the brunt of that. Moreover, 39% salary cuts were planned. Now, each and every employer, just now, Mr. Rishabh said that, so many industries and hotels. Hotels came up with pay cuts that we cannot pay you now. Say, suppose if your pay packet is 100%, we'll pay you, say, 25% of the cut or 50% of the cut. The chief executive officer's pay was cut even to the extent of 75%. And then came up a situation. Government on the one hand is poised with a question as to how many people can work at one point of time. So start the industry with 10% of the workforce or 33% of the workforce. But running an industry with 33% of the workforce does not mean 33% profits. There were no profits. Rather than the profit margins decreased drastically. So friends, what is the scenario today? Just give me a second. I'll have a sip of water and again we'll continue. The scenario today is, after the lockdown, economy indeed is tumbling. Now, you see, this is very important in the fitness of things. Before I tell you as to what are the issues to the lockdown, which is my topic, and this is the context. Economy is tumbling. Employers say we cannot afford the workers, and the managers too. Europe and USA markets are obliterated. Indian economy, government has spent on COVID-19, and there is no money in the public exchequer. Lockdown, you see, so many days there was a lockdown, so man hours are lost. Some industries are almost finished, say for example tourism and hotels, and all of them are equivocal in their voices, wherein they say, how do we pay? I mean the employees, managers and workmen are seen as economic deadweights by the managements, and then the only issue is get rid of them or downsize, that is reduce the workforce. Now, you see, there is no coercive action against private companies. Now, on the one hand, this was going on, time was proceeding. The matters which I mentioned it to you in the Supreme Court, they reached the ultimate hearing. Companies which are closed and where workers were unable to operate during the lockdown, the court in Ficus Pax case, which I just now mentioned, Nagarika Exports and Ficus Pax, on June 4, Supreme Court observed that some negotiations have to happen between employers and workers to iron out what has to be done out for the salary of these 54 days. Now, you see, management started crying fool, wherein they said that how can I pay you when you have not worked, and where is the money? So Supreme Court said that you and the union sit down together and finalize as to what is to be done. Bench observed that both laborers and the industry need each other and should make efforts to solve the dispute mutually. Say, for example, now see a three-judge bench consisting of Justice Ashok Bhushan, S.K. Kaul, and M.R. Shah granted an interim protection from coercive action. Now, you see, there were so many private employers who went to the Supreme Court. They said there are so many issues into this, and how can you ask us, and where is the money? Even if you ask us, from where will I pay? And that is why an interim protection from coercive action was granted by the Supreme Court to all the private employers. I will go a bit fast and delete some slides, because now you see this has affected every industry. Just an example I had taken of sugar industry. Now you see, but sugar industry also came to a standstill. Bulk consumer, in the summer season, we had the peak of the lockdown, and then everybody likes to eat ice cream in summer, but there were no orders. And so the sugar industry, its bulk consumers are ice creams, cold drinks, confectionery. I mean, everything came to a standstill. And then sugar harvesting and transport were also seriously affected, and this also affected working of jaggery units. This is only one issue I took up. Now you see, there are basically two issues. After the lockdown on 18th of May 2020, the central government, by way of a circular which is signed by Mr. Ajay Bhalla, they withdrew all the advisories. So, in simple words, friends, after 18th of May, things became as normal as they were as earlier. That is in February or January. Lockdown is only from 24th of March to 18th of May. Earlier, the labor laws remain the same. So, what is required to reduce the pay? Even today, there are so many industries in Pune and in Maharashtra and in India, wherein people are asking, I mean, the employers are asking that you have to work at a reduced pay. That is 50% of the pay. 25% will be the wage cut. Can you do it under the law? Is what we have to understand. And then there are two sets of people. One, in every industry, we see there are workmen. And the second set of people are the managers. Now, who is a workman? Now, you see, if I am a workman, I'll give you simple examples so that I do not complicate the law. And as far as workmen are concerned, we see that who are workmen? As far as workmen are concerned, and I am a workman, my pay packet is say 100 rupees and my wages are to be reduced. And if this cannot be done, my pay packet cannot be reduced. If I am getting 100 rupees, you cannot pay me 99 unless and until you give me a notice of change, which is required under Section 9A of the Industrial Disputes Act, read with the fourth schedule. Now, this is what is Section 9A. No employer who proposed to effect any change. What is any change? Change in the fourth schedule. I am going to show you the fourth schedule also. Any sort of a change, if you want to change the service conditions, my pay packet is 100 rupees per month. Now you are going to give me 99. You have to give me a 21 days notice for me to challenge your action in the courts of law. I go further. This is schedule 4. What it says, number 1 entry, there are 11 entries in schedule 4. Wages. So you cannot change all of this what you are seeing in the slide unless and until a notice under section 9A of the Industrial Disputes Act is given. What it includes, number 1 is wages, including period and mode of payment. You cannot change 1% also unless you give a notice of change. Contribution paid towards pension fund, provident fund, compensatory and other allowances, which is included in your salary. Your salary has got 4 components. One is basic wages, one is dearness allowance, which in the vernacular is called as a mehengai bhatta. Then is a house rent allowance, and then there are other allowances which is included in Schedule 4. Hours of work, rest intervals, discontinuation of shift, and all of these, whatever you see, introduction of new rules of discipline, you cannot do anything unless and until you give a notice of change. But this is for whom, friends? This is only for workmen. What about managers? And then what is required to reduce pay as far as managers? Managers, you see, first is the terms of employment of any manager are governed under what? The terms are governed. Managers are not workmen within the meaning of Section 2S of the Industrial Disputes Act. So their terms are governed only by the Indian Contract Act 1872, which has got in a way nothing to do with labor laws right now as far as managers are concerned. So their terms can be seen from the appointment letter, that this is the notice period, this is the designation, this is when he is appointed, this is what is his pay packet. And then as far as managers are concerned, SOE standing orders. For those of our friends who are new entrants in the webinar, standing order means rules of an organization. I'll make it simple. See, you and me were in school. Some rules were applicable to us. Then we went in college. You had an identity card, you had a roll number, you had a division. Some rules were applicable to you. Likewise, when people, that is workmen who come in industries, some rules are applicable to them, and those rules are called as standing orders. They are framed under a legislation which is called as the Industrial Employment Standing Orders Act 1946. And this Industrial Employment Standing Orders Act 1946, under that are framed model standing orders. And in state of Maharashtra, model standing orders are applicable when there are 50 people who are employed in any industry. And in the model standing orders, I mean, what are the misconducts, etc., are laid down. Say theft is a misconduct, riotous behavior at workplace is a misconduct, drinking hard liquor is a misconduct at workplace, sexual harassment, likewise. But then standing orders are not applicable to managers. I mean, it doesn't mean that they are allowed to do any misconduct, but only their treatment would be different. And ultimately, managers can negotiate terms with the management. Now, some concepts you see, to know the legalities of removal, what we have to understand in this webinar is to know the legalities of removal of managers and workmen. How can we do it? There are some industries who want to remove workmen because they cannot carry on the show. They want to remove managers, but what is the law involved after the lockdown is the topic of our discussion. So we ought to know some concepts. First is the types of employers and employees. The types of employers you see either are establishments or factories. Say, for example, a bank is not a factory, a hotel is not a factory, a small shop is not a factory, but it is an establishment. And then you are having other factories wherein you see huge factories which are defined more so under Section 2M of the Factories Act, and which basically refers to manufacturing units. Employee is a generic term. We call them workmen and employees. A manager can also be an employee, but a workman cannot be a manager. So employees is a term which covers all types of employees. Workman is a term, I mean, who is defined in Section 2S of the Industrial Disputes Act. And what is that 2S? Workman is a person who to do, don't read the slide, I will make it very simple. He does manual, skilled, unskilled, technical, clerical, operational, and supervisory work. and it includes a person who has been dismissed, discharged, and retrenched in connection with or in consequence of an industrial dispute. Industrial dispute, friends, I mean, we are short of time, but industrial dispute is defined in Section 2K of the Industrial Disputes Act, which is a dispute between workmen, employers, workmen, with respect to employment, non-employment, terms of employment, and conditions of labor of any person. Now you see, this workman, this definition does not include anybody who is subject to the Air Force, Army, or the Navy Act. Logic is very simple. Just think of a situation at Kargil, some war is going on. All our soldiers go there, keep their guns down, and say, Hamari wange puri karo, what will happen to your and my security? So they are out of the definition. And I have underlined something which you can see it in the slide, that is, who this is the non-inclusive part of the definition, but does not include. Who is employed mainly in a managerial or administrative capacity. Managers and administrators, in a way, they are outside the definition, but then who is a manager and who is a workman? Let me tell you, every month there are at least 3 judgments Supreme Court has to deliver as to who is a workman and who is not a workman, and all these are reported judgments. So let us understand who is a workman and who is not a workman. Now this is a parallel definition we have in state of Maharashtra, but I will skip it now. Now we see who is a manager. Workman, I told you, who does manual, skilled, unskilled, technical, clerical, operational, and supervisory work. But then who is a manager? Manager is in SVOC versus Commissioner of Labor. In this judgment, Justice Balkrishna Iyer says he's drawn a distinction between the manager, that is a person employed in the position of management. Now you see, there is a difference between a supervisor and a manager also. Managing affairs, independent decisions, man management is the function of a manager, but keeping an eye over is certainly supervision. An individual has officers subordinate to them who is required to work, then he is a manager. If he is to take decisions and also the responsibility for ensuring that the matters entrusted to his charge are efficiently conducted, then he is a manager. Ascertainable area or section of work is assigned to him, he would ordinarily be justified in saying that he is in the position of a management. So friends, I just quickly sum up. We have 2 types of employees in every industry. One are managers, who fall within the non-inclusive part of the definition of workman, that is, he is not included in the workman. And the second is workman. Now there are tests to determine whether an employee is a workman or not. Otherwise, everybody will say, I am a workman, and all the protections of the labor law should be applicable to me. And these are some of the tests. What is the dominant nature of the employment? If it is manual, skilled, unskilled, technical, clerical, operational, then he is a workman. Now you see, it is not designation of the post which is relevant, but what is relevant is the nature of duty. There was an instance where the management gave visiting cards to an employee and his designation was general manager into bracket sweeping. Supreme Court asked what does he do? He said he sweeps the floor. So they said he is a jhaduwala then, and jhaduwala is manual work. What you call the worker is not important. So designation is not important. Court has to find out whether the employee can bind the company in the matter of some decision. This can be done only by the manager. What are the nature of supervisory duties? Do they include directing subordinates? Otherwise, you have just appointed somebody as a manager, but there are no subordinates, nothing to manage also. Does the employee have power to recommend or sanction leave? These are 2 independent function, friends. And does he have the power to take disciplinary action against the workers working under him? Who takes disciplinary action? These are all the tenets which distinguish a manager and a workman. Does he have power to assign and distribute the work? Does the employee have authority to indent material? Does he have power to supervise the work of men, not only men, but machines also? Say, for example, he is a junior engineer, he is a senior engineer, he is an assistant engineer, he is a deputy engineer, and he is a chief engineer. So the chief engineer will be in the shoes of a manager. Now, does he have any workmen working under him, and does he write confidential reports? Now, there are so many people. Okay. Now, how do you remove workmen? What is the legal way? Because now there are so many HR managers who come to me in my office and they say that it is my management has informed me enough of it. We cannot maintain the economic dead weight of so many workers. So we have to remove some. I mean, it's a sad and sorry state of affairs. They tell me that nobody likes that somebody is to lose a job, but then we have to do it. How can you remove them? One second. Workmen, if at all they commit misconducts under the standing orders, they can be removed by holding a departmental inquiry in consonance with the principles of natural justice. Natural justice are two in number. One is enshrined in a maxim which is called as audi alteram partem, that is here the other side, and the second in another maxim which is called as nemo debet esse judex in propria causa, that is nobody can be a judge in his own cause. Then you have to give him a charge sheet, then there is a procedure of inquiry, then there is a document production, chief examination, cross examination. Ultimately is the inquiry report whether the misconduct is proved or not, and then you have to punish him as per the standing orders. Now for a manager, then inquiry is not necessary, but to be on the safer side, it is better to hold it and give him a right to be heard. Now you see, a second method in which you can terminate employees is by way of a retrenchment. What is retrenchment? Retrenchment in simple words means downsizing. I have say 100 worker, now I want 50. Can I do it? Answer is yes. If at all you employ less than 100 workers. Now this was the situation earlier to 19th of September 2020. On 19th of September, Parliament has passed the Code of Wages, wherein Industrial Code. In the Industrial Code, it is mentioned that this figure of 100 is now pulled up to 300. In simple words, earlier what used to happen for 100 workers, after 100 workers, if you want to say close the undertaking or to retrench workers, you ought to be taking a government permission. And below 100, this permission was not there. Now this figure of 100 is pulled up to 300. It simply means till 300 you cannot, you should, or you need not take any permission from the government. But then what you have to do, you have to just follow section 25F of the Industrial Disputes Act. Again, I will tell you, don't read the slide. That is more complicated. I'll make it simple. Now, conditions precedent to workmen, retrenchment is downsizing. In Parry and Company's case, Supreme Court said it is the employer who is the sole judge to decide what workforce he wants. Promotion is a management function. Work allocation is a management function. Then who is to work where, that is a management function. Likewise, I mean, the employer is to decide whether he wants the workman or not. And if he cannot maintain the economic deadweight of the workman, he cannot be forced to do it. But then there are certain rules. He has to follow section 25F, so which is a condition precedent. That is, he has to pay a retrenchment compensation of 15 days of average pay per completed year of service, and that has to be paid first. And then as per the seniority, he will make a category wise seniority list in accordance with rule 81 of the industrial disputes rules, and then retrench the workers. I go further. Now, exceptions to the retrenchment: non-renewal of contract. Retrenchment is defined in section 200 of the Industrial Disputes Act, and I will directly take you to the blue part of the. Now you see, suppose if somebody is appointed on contract and his contract is not renewed, that does not constitute termination. It is not termination, it is non-renewal of contract. And what does the section say? Termination of service of the workman as a result of non-renewal of the contract is exception to the retrenchment. So you can say, I'm not extending your contract, and if I'm not extending your contract, you lose your job, but I'm going to pay you whatever is the retrenchment compensation. That will be a bonus, because this is an exception to the retrenchment. For non-renewal of, see, in simple words, I'll make it still simpler. Non-renewal of contract is not considered termination, neither is it considered retrenchment. Let's go further. Now, how do you remove managers? You understood how to remove workers, how to remove managers. Sometimes in industries, there are so many managers, and now all of them have attained senior positions, and then they have to be removed, is the mandate of the management, and HR managers have to listen to that. Who is a manager? Answer is very simple. One who is not a workman is a manager. Supervisors, are they managers? You have to apply the test which is called as a DNT, that is the dominant nature test. And the law relating to master and servant is clear. A contract of personal service will not be specifically enforced by an order of specific performance. In simple words, a manager cannot say that you must keep me on the job because he is not protected, for the simple reason that he is economically protected. It will not be open for a servant to refuse to accept the repudiation of contract by his master and say that the contract has never been terminated. And moreover, let me make it simple. If a manager is terminated, for your information, where can he go? He is not a workman, so the doors of the labor industrial court are closed to him. A manager can only go in the civil court, but civil court does not have a power to reinstate him. So what can he ask? He can ask only for a declaration. Let's go further. So the plight of the managers is really, the plight is that we have to enact a legislation wherein which will provide protection to the white collar employees who are illegally terminated. Do you think all managers are very legally terminated? No, half of them are terminated for say irrational reasons only. Which court can he go? He goes to the civil court. In every nook and corner of India, it's going to take donkey's years for the case to get solved. So what? So what can the manager do? Today he can do in a way nothing. But then, friends, those of you who are managers who are attending this webinar, there is some silver lining and a good news for you. That is that in the present industrial court, there is a separate court created for managers wherein they can file cases. Okay. And the last line in the grade, you see it's imperative to safeguard such managerial employees by enacting the legislation. Now, this is a slide which I made it earlier to 19th of September. And then now the legislation has come. There is basically going to be a separate court also, which is a good news for managers. Now, how to safeguard? Apart from taking civil action for seeking specific performance, injunctions, that is stay orders, or damages which takes ages to be decided, and the parties may also resort to arbitration. These are the new things which are introduced. The arbitration, that is having a common umpire, that is also necessary. And the body which will be created under code of wages will act as a tribunal in case of the one which acts like for workmen today, the same will be as far as managers are considered. Okay, so all this can be, now you see, but today I am saying, that is after the notification this will come into picture. But today the notification is not there, though parliament has passed a bill. Three well recognized exceptions to the rules are basically a public servant. Supreme Court laid down that no declaration to enforce a contract of personal service will be granted. That is, a contract of personal service, friends, technically speaking, cannot be enforced under Section 14 of the Specific Relief Act 1963. But there are three exceptions. One, public servant, all your IAS officers who have been dismissed in contravention of Article 311 can be reinstated back. Reinstatement of a dismissed worker or under industrial law by labor or industrial tribunals. If you dismiss a worker illegally, the labor or industrial tribunal will grant him a reinstatement. And third is a statutory body worker. What is a statutory body? LIC is statutory body, Konkan Railway is statutory body, Maharashtra State Farming Corporation is a statutory body. All people who are dismissed from such bodies can again be granted a reinstatement, are the exceptions. Otherwise, managers outrightly, what they want is, if he at all is terminated, he wants his service back. But a contract of personal service cannot be specifically enforced. Okay. So these are the settled principles. I'll be a bit faster. And no declaration to enforce a contract of personal service will normally be granted. Apex Court, that is Supreme Court in Indian Airlines Corporation versus Sukhdev Rao, held that it is a well settled principle that when there is a termination of contract of service, a declaration that the contract of service still subsisted would not be made in the absence of special circumstances, because of the principle that courts do not grant specific performance of service. I will not read purposely the rest of the slide, I should not complicate. Now you see, I just now told you the contract of personal service cannot be specifically enforced under Section 14 of the Specific Relief Act. And then cases of dismissal of a servant fall under three broad heads: purely by contract of employment, wherein there will be no reinstatement, isn't it? Just now I told you. And any breach of contract in such cases is enforced by suit for wrongful dismissal and damages. What you can ask from the civil court? Civil courts itself do not have the power of reinstatement. So what you can ask are only damages. And then uh, such you cannot a manager cannot ask for restoration of his service, because such a declaration is not permissible under the specific relief act, and this relief is available under labor industrial law. So you see, all workmen will ask for a reinstatement, but no manager can ask for a reinstatement because civil court lacks that power. Lastly, this has got a nexus or a connection with the unfair labor practice also. Now you see, it applies to sugar cooperatives in Maharashtra and all other industries. Now, who are covered here? All factories are covered under this notion, whatever I am talking. All IT industries are covered, all hotels are covered, all sugar factories are covered, and everybody is covered. Means what? Any industry which can be spelled out as an industry under Section 2J of the Industrial Disputes Act is covered. There is hardly any industry which is left out. Otherwise, whatever I spoke applies to every industry. Now, the last element is unfair labor practice. In state of Maharashtra, we have another legislation which is called as the Maharashtra Recognition of Trade Unions and Prevention of Unfair Labor Practices Act. It applies where Industrial Disputes Act applies, and as well as Maharashtra Industrial Relations Act applies. Let us not go into technicalities. I need not want to confuse you. Now you see, a workman, if he is outrightly dismissed, can challenge the action of the management, saying that it is an unfair labor practice. But what is an unfair labor practice? Unfair labor practice is defined in item number 1 of MRTO and Pulp Act, when a workman is terminated from his service, dismissed from his service, or in simple word, there is a loss of service. As far as item 2 to 10 are concerned, in those situations, the workman has to be in service. And item number 1 applies when a workman is out of the service, whether by way of a compulsory retirement, dismissal, discharge, whatever you can call. Now, this item 4, schedule 4 of MRTO and Pulp Act, this is a state legislation, but then the popularity of this act is too high in state of Maharashtra. This was sensed by the central government, and then they amended the Industrial Disputes Act and introduced a schedule which is called as Schedule 5, which is the same as Schedule 4 in state of Maharashtra. In simple words, all unfair labor practices all over India remain the same. Okay, I go further. This is a list of unfair labor practice. What is this? I'll quickly read it for you. To discharge or dismiss employees, how? By way of victimization, that is making a person a scapegoat or a balika bakra, and then not in good faith, but in the colorable exercise of the employer's rights. Then, colorable exercise of employer's rights means that which you cannot do directly, you cannot do it indirectly also. And then by falsely implicating employees in a criminal case on false evidence or concocted evidence. Patently, you terminate employees for false reasons, trumped up allegations of absence without leave, then utter disregard of the principle of natural justice in the conduct of a domestic inquiry. You make a farce of an inquiry, that I'm going to hold an inquiry, but you don't grant principles of natural justice to him. Then for all of these things, the court will declare that you have indulged in an unfair labor practice. Or say, for a misconduct of a minor character, you punish a person and the punishment is shockingly disproportionate so as to shock the conscience of a reasonable man. Then all such practices are unfair labor practices. So friends, just to sum up, we saw treatment for managers is different, treatment for workmen is different. And if you don't follow this, then the workman might challenge you that your action smacks of unfair labor practice. Okay. Now, where can managers challenge? You have to see the rules. Some companies have rules, but 99.9% it is the civil code, because that only has the jurisdiction. Some managers say, I am a manager, I will directly go to the High Court, and they insist upon lawyers to go to the High Court. In that situation, High Court will remand your matter back. Because civil, now you see, the original court is civil court only, so you have to come. Otherwise, what is the use of having a civil court? Every manager will say, I will go to the directly to the high court. If the rules say yes, then he can go to the high court. Civil court has got no right of reinstatement, but it has got a right only of declaration, that it can just declare. And that is why, this is the reason, friends, you will find that 99% of the workmen challenge the decision of the management and go to the labor industrial court, whereas 99% of the managers do not even challenge the action of the management and they seek another job. There is no removal today, and with whatever were the advisories, no, don't remove, but how will I maintain them? Last week we have retrenched some 14 employees from one industry. How do we do it? And the answer is, and after the post lockdown, things are as normal as they were in February. So what I spoke is, I told you as to what was the position before the lockdown, during the lockdown, after the lockdown. After the lockdown, what is the state of advisories, whether you can terminate people, whether you can reduce their salaries. If at all you can terminate, again two types of people, one is workmen and managers, how you can terminate the managers, how you can terminate the workers, and whether section 9A is applicable and what constitutes an unfair labor practice. Now you see, in order to revive the ill effects of the corona package, the government came with a big bang package, that is extra capital for farmers, equal pay for equal wages. Today it is only 30%. National floor wage versus minimum wage, they are made separate now. Kisan credit cards, it's helped 2.5 lakh farmers, easy loans they get, fisheries. Then there were PF relaxations. Government paid, relaxed it for 2%. And for some industries, they even paid the PF. Now, urban poor is another segment itself. People who stay in Juggi Jhopdi and slum areas in cities, for them housing, food, medicine, government made arrangements, a big bang package. One nation, one ration card for migrant labor. Manrega, minimum wages is increased from 182 to 202. Definition of migrant workers itself is changed and they have been granted benefits. Women can work during the night, even under the code of wages. Now there is no need of a permission. They can work at night. Hawkers and peddlers, there is a gubbare wala or somebody selling ice cream, and the person who comes in your street, now 10,000 rupees capital is given so that they can also again start their business. And middle low class housing, they have been granted a credit link subsidy. Now this is a big bang package by the government because there were devastating effects as far as the corona is concerned. And friends, it is almost 1 hour I am talking with you, and it is also time for me to stop. So this is my email and this is my cell number, and now it's time for your question and answers, and I would be more than delighted to answer your questions. Okay, if at all there are any. In whatever is the limited time, I told you and summarized as to what we spoke, and this was after the lockdown. And yet we are going to see many more things which are yet to come, which you don't know what nature has in store for us, because the vaccine is not yet invented. And many of them have tried. I mean, people are trying it all over the earth, but many tests have failed. And we can only say that after 100 tests, naturally, we'll not lose hope that one day we will have a vaccine for corona. So I stop my webinar and then I would be delighted to answer your questions. Thank you so much. Okay.
Rishabh sir, unmute.
Yeah.
Sir, thank you so much. You have really summarized very well, not only the lockdown and before and after as well. And from a very layman, non-legal person perspective, I really applaud you for that. Here are a few questions which I'll ask from the comments. Mr. Adarsh is asking,
Yeah.
if employee is terminated because of misconduct or absconding, then does he have to in IT and BPO industry, does he have to report to labor department?
See, if an employee is whether workman or manager, there are two elements to that. Absconding is another part. Absconding is if a person absconds, question is there must be some leave to his credit. So whether that has been exhausted. After that, even if he doesn't turn up, Today, situations have come under model standing orders, that is the rules of an organization. When a person absents himself, after 10 days, the misconduct starts. Absenting himself after 10 days, then the real misconduct starts. But if you can terminate him on the 11th day, can you do it? Answer is no. If he goes to the court of law, they will say, what about humanitarian grounds and what about humanity? Take him back. So the safe margin in labor industrial courts is almost 90 days. That is 3 months if he is not reporting. Then you can say, not absconding, that's a wrong word. He may have absconded, but that is absence without permission. That is the real misconduct. Permission in the sense is, absence without leave is leave in the sense of a permission. As far as managers are concerned, there is no real rule which applies to managers. And if at all they don't like a manager, even today hire and fire operates the scene. They can tell a manager, we don't like your services. Come on, either we terminate you or you give a resignation. The managements can do that even today. Okay, but that cannot be done with respect to workmen. As far as IT people are concerned, same rules apply to the IT people also. There is no exception carved out in any law.
So
Yes.
they do they need to report to labor department or they don't need to?
No, if at all a person is a workman, he may be working in an IT company also. Workman, I again repeat, is a person who does manual, skilled, unskilled, technical, clerical, operational, and supervisory work. If he is terminated or he senses termination or whatever, he can certainly go to the labor office.
Okay.
Managers cannot go. He
Right.
has to go only to the civil court. Yeah.
Okay. Sir, you talked about unfair labor practices. There
Yeah.
is a practice of, I guess you are aware of this, forced resignation, where employers stop giving salaries or
Yeah. Yeah.
get the resignation letter signed in advance. So, what is there any way for a manager or employee to challenge that?
Yes. See, many people, both the things happen. Some people are really forced to resign. Some have resignation thrust on them, that is forced resignation. Some voluntarily resign and after taking all the emoluments, make a UN cry that this was forced resignation. In that situation, if at all he goes to the court of law, see, now I have to go a bit deeper in law, which you please allow me. Indian Evidence Act 1872 applies to a person, and under the Indian Evidence Act, there is a maxim affirmati non negandi incumbit probatio. So the burden of proof is on the one who alleges. The moment you say that I have been forcefully terminated, burden of proof is on you. Prove it. That's what the management says. And then when it comes to the court of law, in a cross examination, the lawyer asks him that, okay, who forced you? He really has no answer. And then even if he says, come on, okay, he becomes bold, and then they says this manager and this manager, they both forced me. Okay, then what is your education? Are you matriculate? Yes. Do you know that there is a thing called as a police station in India? And he has to say yes. And then if you are forcefully terminated, did you make a police complaint? Now in that situation, he's never made a police complaint. Because if he says yes, he says, come on, give me a copy of the complaint, which has to be dated on that day. It goes that to that end. And then they tell him that, no, I don't have a police complaint. I'll see. Then the suggestion is, I'll tell you why you did not make a police complaint, because these people did not force you only. So
Right.
proving forced resignation is not that easy. Making an allegation of forced resignation is almost fashionable. That's different. Yes.
Okay. Sir, one question is, you talked about that notice must be given to workmen for reduction of his salary and various other changes. In case of manager, is there any legal way, if we say rewrite the employment contract or any other legal way through which we can reduce the salary? And what is the stand of various other acts like PF and ESI? Do they allow reduction in salary?
No, basically PF and ESI has got nothing to do with reduction of salary. What is PF? PF and ESI are both social security legislations. PF is, if suppose my pay packet is 100 rupees per month, 12% will be employer's contribution, 12% is employee's contribution, 1% is the administration tax, and then all pulled up together, 25% will be deposited in the account of the Provident Fund Commissioner. That is my monthly PF. ESI is, I mean, till whose wages are till 21,000 rupees, 3% of the from the employer and 1% from the employee. That's like an insurance premium, which has got nothing to do with reduction of pay. As far as managers, your question, Manager, the terms and conditions of service are controlled not by standing orders or anything, but they are controlled by the Indian Contract Act 1872. So it's like a sabzi mandi hisab. I go, I say that I want a lakh of rupees. I am a manager. Management says, okay, so I am a manager and my pay packet is a lakh of rupees. And because I am a manager, tomorrow they can say, okay, we don't require your services. Otherwise, work at 50,000 rupees. Now the ball is in my court. I say yes. I told you it's a sabzi mandi hisab. If I say yes, say, because there is no protection to managers in this country for the simple reason, the logic behind it is that they are economically protected. So there's no protection for a manager. Yeah. I cannot hear you.
Okay, I guess now is it clear now?
Yeah. Now
Yes.
I can hear you.
The one very basic question is coming. You mentioned 4 terms: dismissal, discharge, retrenchment, and termination. Can you elaborate on them a bit? What is the difference?
I'll have to give you an example. If you can bear with me for 2 minutes, then I can elaborate it in a better fashion.
Sure,
Say,
sir.
what is a dismissal and what is a discharge? I'll tell you, I'm a manager and I'm a very soft-hearted manager. There are different types of managers. There are good managers, there are bad managers, there are ugly managers, there are weak managers, there are meek managers, there are submissive managers, there are arrogant managers. Full lot is available. And I am a very soft-hearted person. Shift begins at 8 o'clock. It's written in the standing orders, that is the rules, and the worker comes at 8:15. He's late. Coming late is a misconduct. So I tell him, you are late, and he says, sorry. Then I told you I'm soft-hearted, so I said, okay. Next day the worker comes at 8:30, and then I say, what's the matter? And again, sorry. But I am soft-hearted, so I say one more chance. Then he comes at 8:45. Then I call him, hold my watch in front of him. What's this? Dekho kitne baje? And again, sorry. Next day he comes at 9. How long will this continue? So ultimately, I call him in my office. I call my typist and say, "Come on, to the best of it, of my knowledge, information, and belief, you bear a good moral character. But you are good, I am good. Not necessary. Though अच्छे आदमी cannot pull up with each other. You are
Right.
discharged from your service." So I discharge him. Discharge is a polite way of saying get out.
Okay.
Get out remains, but it's a polite way of saying get out. It's a discharge. Second example is the same example. There is a worker, but this time I am not a soft-hearted manager. I am a wicked despot. And this worker, he comes at 8:15. I lose my temper. And then I call him, give him a big bhashan and give firing. I said, we are all fools here coming here at 8 o'clock. तुम कौन से बादशाह लग के गए हो? पागल तो नहीं हो गए? There is that. I tell him, see, don't tell me, you don't know who am I. Tomorrow you are 1 second late, then you really had it. And I know you have school and college going children, you have taken up EMIs and loans and this and then don't tell me you will be on the road. Next day he comes at 8:30. 8:30, I lose my head. I call him, I said, you are outrightly dismissed. Don't teach me inquiry and this and that. Go to whichever Supreme Court you want. You are dismissed. Then what happens, see, everybody wants to make a living. So both of them, he goes to some other industrial estate. And in India, itihas is very important. Pehle kidhar tha? So they ask him, he says that, okay, to go there, come back, it was very cumbersome. So they have discharged me. Discharge is polite way of saying get out, but there is no stigma in it. Everything is clean. And then they say, okay, from tomorrow join. In a dismissal, this does not happen. In a dismissal, there is a stigma attached to a person. And then in the dismissal order, you are dismissed from your service, rude behavior, unpunctuality, this, that. So the another employer says, ये तुम्हारा ही है ना? What is it written? Rude behavior. ये वो. नहीं, नमस्ते, वो कोई दूसरी कंपनी देख लो. So in a stigma, so I'll just sum it up in a way. In a dismissal is a blunt way of saying get out. Discharge is a polite way of saying get out. Dismissal is dishonorable. Discharge is also dishonorable, but discharge is not that dishonorable as that of a dismissal. That is the difference. The difference is of the word that only. Discharge is dishonorable. Dismissal is also dishonorable, but discharge is not that dishonorable as that of a dismissal. I'll explain the meaning of the word that in a quick second, and then we'll go further to the next question. It's a story. Mullah Nasruddin was on his wife was on her deathbed. She was to die. And Mullah Nasruddin was sitting next to her. And at that point of time, the wife asked him a question that, darling, if I die, what would you do? Mullah Nasruddin looked at her and said, darling, if you die, I will turn mad. The wife smiled at him even at that point of time and said, you cunning fellow, I know you throughout my life. The moment I die, you will get remarried. Mullah Nasruddin looked at her with philosophic calm and said, darling, I told you I will turn mad. I will not turn that mad to remarry again. So that indicates degree. That is the difference between these two words.
Thank you, sir. Thank you. That was a very nice explanation. Last question is coming. Many a times, PF inspectors they object that how have you reduced the basic wage of particular employee? So
basic. Continue.
Do they have the power to do that? And even in lockdown, they issued a circular that you should not reduce wages of any employee. So, do they have the power to enforce
No, this power is not with Provident Fund. Inspectors have a power relating to Provident Fund. Reducing the wages is something else. Provident Fund inspector, what he would do is, what would be the basic wages? He has got a point in that. Moreover, if you see, the practice is that 45% of the basic wages out of 100 is also legal. 50% is also legal. 60% is also legal. Higher is no problem. You can even deduct to make the thing at 80% of the basic wages. Because you see, your provident fund, your ESI, your bonus, and your gratuity is all calculated on basic DA. ESI is on gross, but which includes basic DA. So some people, what they do, 10% of basic, and then the remainder would be other allowances and HRA and all those things. So if I'll give you an equation, say for example, if 100 rupees is my pay packet, so at 12% is 12% of my pay, 12% employee and 1% of tax is equal to 25% is equal to Provident Fund calculation per month.
Right.
When my basic is 50 rupees, if I make it 50 rupees now, on 50 rupees, it is 6 rupees, 6 rupees and 1 rupee. But if I make it 10 rupees, it will be 1 rupee 20 paise, 1 rupee 20 paise. So I get 2 rupees 40 paise. So what you are doing in a way is, how much should be the basic DA? It should be somewhere around 50%. It's a social security legislation. If you make it 10%, I mean, you are taking away the social security only of a person. Suppose if it is 50 rupees basic DA, so my provident fund per month becomes 12 rupees. But when it is 10 rupees basic DA, my provident fund rupee becomes rupees 2 rupees 40 paise.
Right.
And this is on when my pay packet is 100 rupees. I mean, 100 I have taken just a figure. So that is the difference. That is how it operates.
You should not reduce. Your contribution should not reduce.
Your BPA basic cannot fall below, say, in normal terms, 50%.
Right. Just a follow-up question on this, sir. In the lockdown, you see that many people are working from home. So now, in that particular scenario, can companies stop giving them like conveyance allowance or traveling allowance because they are not traveling to work?
They may, but then again, you are changing service conditions. And I told you, Schedule 4, read with Section 9A of the Industrial Disputes Act, then you should have some consent from them also. That yes, as it is, they are saving, isn't it? Some change in service condition is there.
Is
today,
email enforceable? Like, is it okay if we take approval or send them mail regarding this?
Email is now an admissible piece of evidence under the Indian Evidence Act 1872. That is fine.
Okay, sir. I guess yes. That concludes all the questions. Everything. Yes, I've checked. Thank you so much, sir, for giving your valuable time, and it was very enlightening for us.
My pleasure. My pleasure.
Thank you from bottom of my heart and from all the community.
Yes, thank you. Thank you so much. Yeah. Bye.
Sorry, तो दोस्तों उम्मीद करता हूँ आज का वेबिनार आपको इंटरेस्टिंग लगा होगा, और इसी तरह से आप जुड़े रहिए लेबर लॉ एडवाइजर चैनल के साथ। अगले सैटरडे को हमारा एक और वेबिनार होने वाला है। इस बार वेबिनार का जो हमारा विषय रहेगा वो रहेगा पीएफ इंटरनेशनल वर्कर। एक बहुत ही कॉम्प्लिकेटेड टॉपिक है जिस पर हम लोग अगले 3rd को बात करेंगे, और उसकी भी डिटेल्स आपको हमारे व्हाट्सएप ग्रुप पर या कम्युनिटी पर मिल जाएगी। अगेन, आप में से कोई मेंबर अगर ये वेबिनार देख रहे हैं और अभी तक हमारे ग्रुप का हिस्सा नहीं बने, तो एक बार आप हमें ईमेल पर अपना व्हाट्सएप नंबर ड्रॉप कर दीजिएगा, हम आपको ग्रुप में भी ऐड कर देंगे। आज के वेबिनार आपको कैसा लगा इसके बारे में हम जरूर हमें कमेंट्स में बताइएगा। हम सर के साथ भी आपके फीडबैक या आपके जो भी बातें हैं, जो कमेंट्स हैं, वो सर के साथ शेयर करने की कोशिश करेंगे। चलिए, इसी तरह अपना ध्यान रखिए, अपने परिवार वालों का ध्यान रखिए। लेबर लॉ एडवाइजर टीम की तरफ से, मेरी तरफ से बाय, जय हिंद, जय भारत।